YouTube, it's Tom back with another one for you. And so this one is a continuation of the redemption manual, and we're gonna get into why we do the UCC filings. So this will kind of break it down for you here. So let's get right into this shit here. Why the UCC filing? Around the time of the war between the United States and the southern states of the American Union, the United States was busy putting together their plan that would increase the jurisdiction of the United States. This plan was necessary because the United States was in debt, had few subjects, and only the land ceded to it from the states, i.e., the District of Columbia, which was only 10 miles square, and such other, give or take, and such other necessary was only for forts, magazines, and arsenals. So the United States is 10 miles square in the District of Columbia. That's what the United States is. It sits on America, okay? America is the rest of the land. So between the 1860s and the early 1900s, banking and taxing mechanisms were changing through the legislation. Cunning people closely associated with the powers in England had great influence on the legislation being passed in the United States. Of course, such legislation did not apply to the states or to the people in the states, but making the distinction was not deemed to be a necessary duty of the legislatures. It was the responsibility of the people to understand the relationship between the United States and to the laws that were being passed by the legislature. This distinction between the United States and the states were taught in the homes and the schools and churches. The early admiralty courts did not interpret legislation as broadly at the time because the people knew when the courts were overstepping the jurisdiction. The people were in control because they knew who they were and where they were standing in relation to the United States corporation. So, in 1913, the United States added numerous private laws to its books that facilitated the increase of the subjects. The newly so-called free slaves from the Civil War as property as the United States, the 14th Amendment provided for a new class of citizens. United States citizens that had not been formally recognized until the 14th Amendment in 1868. There were no persons born and naturalized in the United States. They had all been born or naturalized in one of the several states. United States citizenship was a result of state citizenship. After the Civil War, a new class was recognized and was the beginning of the democracy first positioned in the District of Columbia. The American people in the Republic, to be found in the several states, could choose to benefit as one of the new United States citizens by choice. The new class of citizens was given the privilege to vote in the democracy in 1870 by the 15th Amendment. The new citizens subject were required to apply for marriage, register to vote, register births, deaths, and all it required was an application. Benefits came with the new citizenship, but with the benefits came duties and responsibilities and liabilities that were totally regulated by the legislature for the District of Columbia. Edward Mandell House is attributed with giving a very detailed outline of the plans to be implemented to enslave the American people. The 13th Amendment in 1865 opened the way for the people to volunteer into slavery to accept the benefits offered by the United States. Whether House actually spoke the words or not really irrelevant because the scenario detailed in the statement attributed to him has clearly been implemented. Central banking for the United States was legislated with the Federal Reserve Act of 1913. The ability to decrease the currency in circulation through taxation was legislated with, let's see what they got here, was legislated with the 16th Amendment in 1913. Support for the presumption that the American people had volunteered to participate in the United States democracy was legislated with the 17th Amendment in 1913. The path was provided for the control of the courts by British Crown with the creation of the American Bar Association, British Accreditation Registry. That's what the bar stands for. In 1917, the United States legislature passed the Trading with the Enemy Act and the Emergency War Powers, opening the door for the United States to suspend limitations otherwise mandated in the Constitution. Even in times of peace, every contrived and created social, political, or financial emergency was sufficient authority for the officers of the United States to overstep its peacetime powers and implement volumes of law, quote unquote, that would increase the coffers of the United States. There is always a declared emergency in the United States and in states' administrative units but it only applies to their subjects, okay? Their fucking employees are the only ones that they can dictate or have any mandates toward or for, okay? In the 1920s, the states accelerated the push for mothers to register their births as first required upon the new federal property. The so-called freed black slaves' life was good, and people were not paying attention to what was happening in the government. The stock market crashed, and those who were not on the inside were warned to take their money out before they lost everything. In the 1930s, a federal legislation provided for registration of babies through application for birth certificates. So government workers could get maternity leave with pay. The states pushed for registration, surrender of ownership, which is what registration is. The key word here in registration is regis, okay? So that has to do with monarchy and patriarchy and shit like that, all right? So surrender of ownership of cars through applications for certificate of titles, and for registration of land through registration of deeds or trust, which turned the land over to the state. Constructive trusts were secretly created at each of the people blindly walked into the United States democracy, thereby agreeing to be sureties for the debts of the United States. The Great Depression supplied the diversion to keep the people's attention off what the government was doing. The Social Security program was implemented along with numerous and other United States programs that invited the American people to volunteer to be sureties behind the United States, new registered property, and adhesion contracts through the United States subjects. The plan was well on its path by 1933. Massive registration, surrender of property through United States agencies, including the state, quote-unquote, subdivisions. The states are subdivisions of the United States, okay? So that's why United States Code is going to apply in any of their bullshit codes and statutes, all right? So was assuring that the United States and its officers would get rich beyond their wildest expectations. All of this was done without full disclosure of the material facts that accompanied each application for registration. Is that fraud? Absolutely. The fraud was a sufficient reason to charge all the United States officers with treason, unless a remedy could be supplied for the people to recoup their property and collect for damages what they had suffered as a result of the fraud. If a remedy was available and the people chose not to or failed to use the remedy, no charge of fraud could be sustained even in common law court, right? So they always leave the door open, and so they can't really fuck with you if you try to leave, but they'll try to just scare you into not doing it and shit like that. But so they leave the door open in order for them not to be charged with fraud, and everything's right out in the open for you to find, you know. So the United States only needed to provide the remedy. It was not required to explain it or even tell the people where the remedy could be found. The attorneys did not even have to be taught about the remedy. That gave them plausible deniability, and that's how they operate. It's plausible deniability. So they fucking pretend not to know. So when you put them on notice, they'll fucking dismiss the cases ASAP because they can't have those on the record and move forward in good faith with clean hands, because then they'll, you know, you have proof that you already put them on notice that what they're doing is a criminal act. So they can no longer move forward and charge anybody with the same shit after you put them on notice. So they fucking dismiss it and get it out of their courtroom ASAP. Okay. So when the people struggled to understand the new laws, the legislature did not have to have the intricate details of the new law explained to them regarding the bills that were passing. That gave them plausible deniability. If the people failed to use their remedy, the United States came out the winner every time. If the people did discover their remedy, the United States had to, let's see what they had to do. The United States had to what? Had to honor it and release the registered property back to the people, but only if the people knew that they had a remedy, and only if they requested it in a proper manner. It was a great plan. With plausible deniability, even when the people knew that they had a remedy and pursued it, the attorneys, judges, and legislatures could act like they did not understand the people's claims, requiring the public schools to teach civics, government, and history classes out of approved politically correct textbooks also ensured that the people would not find the remedy for a very long time. Passing new state and federal laws that appeared to subject the people to rules and regulations added another level of protection against the people finding their remedy. The public socialist media was molded to report politically correct, though substantially incorrect, news day after day until few people would even think that there could be a remedy available to them. The people could be separated from their money and their time to pursue the remedy long enough for the solutions to be lost in the millions of pages of books and huge law libraries across the country. So many people knew that there was something wrong with all the conflicts in the laws with the facts taught in the government schools, but how can the American people be free and subject to a de facto government's whims at the same time? Who would even have thought that the people would be resourceful enough to actually find the remedy? But they did. All right. So, two, in 1933, the United States put insurance policy into place with the House Joint Resolution 192 and recorded it with the congressional record. And so this is all codified in every state as well. So you got HJR 192, Public Law 7310, right? And so that's all going to be codified also as well in any of your codes and state statutes as well, because it has to be, right? And so that's your right to discharge any debt based on the fact that there is no actual money in circulation here. Okay, so an executive order was issued on April 5th, 1933, which paved the way for the withdrawal of gold in the United States. Representatives Louis T. McFadden brought formal charges on May 23rd, 1933, against the Board of Governors of the Federal Reserve Bank System, the Comptroller of the Currency, and the Secretary of the United States Treasury. Congressional Record, May 23rd, 1933. Mr. Chairman, we have in this country one of the most corrupt institutions the world has ever known. I refer to the Federal Reserve Board and the Federal Reserve Bank. HJR 192 was the insurance policy that protected and guaranteed the legislatures and out from conviction for fraud, treason against the American people. It also protects the American people from damages caused by the actions of the United States for speaking like he did. Mr. McFadden was poisoned by the powers that be by agents of that federal corporation. HJR 192 provided that the one with the gold pays the bills. It removed the requirement that the United States subject and employees had to pay their debts with gold. It actually prohibited the inclusion of the clause in all subsequent contracts, which would require payment in gold. It also canceled the clause in every contract written prior to June 5th, 1933, that required an obligation to be paid in gold retroactively. It provided that the United States subjects and employees could use any type of coin and currency to discharge a public debt as long as it was in the normal course of business. And so you can use any coin of the realm, which is fiat currency, promissory notes, which you have every right to issue just as well as the privately owned Federal Reserve banks, okay? In the United States, and so that's the whole purpose of filing a UCC, because you're establishing a value on the bond, and so you can write promissory notes based upon the value of the bond. Okay, it's going to be written fucking against the value of that bond using the financing statement, which is what your UCC 1 financing statement is. Okay, so for a time, United States notes were the currency used to discharge debts, but later the Federal Reserve and the United States provided a new medium of exchange through paper notes and debt instruments that could be passed on to the debtors' creditors to discharge the debtor's debts. The same currency, Federal Reserve notes, is used to discharge public debts. Take note, the Federal Reserve notes have no value as stated by the Federal Reserve, and they don't. A promissory note is a promise to pay. Okay, that's what it is. So if you've been getting paid in promissory notes by your job or by the banks, you've never gotten paid. They're all just promises to pay. In the 1950s, the Uniform Commercial Code was presented to their states as a means of unifying the generally accepted procedures for handling the new legal system of dealing with commercial transactions and fictions as though they were real. Security instruments, commercial papers, replaced substance as collateral for debts. Security instruments could be supported by presumptive contracts. Debt instruments with collateral and accommodating parties could be used instead of money of exchange, and the need for money was disappearing, and new money was being created, money of account, created by a bill of exchange, and a uniform system of laws had to be put in place to allow the commercial venue and the courts to uphold the security instruments that depended on commercial fictions as a basis for compelling payment or performance. The commercial code is merely a codification of accepted and required procedures all people engaged in commercial activities must follow. The basic principles of commerce had been settled thousands of years ago, but were refined and became more sophisticated over the years. In the 1900s, the old age principles of commerce shifted from substance to form. Presumption became a big part of the law without giving a degree of force to presumption. The new direction in enforcing commercial claims could not be supported in their courts. If the claimants were required to produce their claims every time they tried to collect money or time from the people, they would seldom be successful. The principles expressed in code combine the means of dealing with substantive commercial activities with the means of dealing with the presumptive commercial activities. These principles work as well as the people as they do for the deceivers. The rules do not respect persons. So those who entice the people to register or surrender their property, land, cars, guns, children, to the subdivisions of the United States under dictate by the United States, gained control of the substance through the registrations, and the states were able to exact use taxes from the people use of the property of the state. The states in the United States became the holder of the titles and all the property, even children and many other things, right? So the definition of property is the interest one has in a thing. The thing is the principal. The property is the interest in the thing. Profits, interest made from the property of another belong to the owner of the thing. Profits were made from the deceivers by pledging the registered property in commercial markets. But the profits do not belong to the deceivers. The profits belong to the owners of the things. This is always the people. The corporations only show ownership of paper titles to things. The substance cannot appear in the fiction. Watch the movie The Last Action Hero and watch the confusion created when they try to mix substance and fiction. Sometimes the fiction is made to look very much like substance, but fiction can never become substance. It is an impossibility. The profits from all the registered things had to be put into a constructive trust for the benefit of the owners. If the profits were put into a general fund of the United States and not into separate trusts for the owners, the scheme would represent fraud. The profits for each owner could not be commingled. If the owner failed to use his available remedy, fictional credits held in a constructive trust fund or financial ledger to benefit from the profits, it would not be the fault of the deceivers. If the owner failed to learn that the law would open the door to his remedy, it would not. What would it not? It would not be the deceivers. The owner is responsible for learning the law. So he understands that the profits from his things are available for him to discharge debts and charges brought against his public person by the United States. If the United States has the gold, the United States pays the bills from the trust account, the fund, or financial ledger. The definition of fund is money set aside to pay debt. The fund is there to discharge the public debt attributed to the United States subjects, but ultimately back to the accommodating parties, the American people. The national debt is what is owed to the owners of the registered things, the American people, as well as to the other creditors. So what this is saying here is that the national debt is not money that is owed to these fucking clowns. It is money that is owed to you. So for $30 trillion in debt, that's what they owe the American people. Okay, so that's how that shit works. Debt is money. Okay. So the problem is that nobody's filing their taxes correctly to close the circuit to get their fucking refunds back. But everybody is owed all of that money. Know that. All right. So that's what the whole OID process is all about and shit like that. It's from getting your money back on the private side and showing up as a debt because nobody's claimed it to fucking neutralize it. All right. So if the United States owes a debt to the owner of the thing, the owner is presumed by accommodation to owe a public debt to the United States. The logical thing is to ask the United States to discharge that public debt from the trust fund. The way for the United States to get around having to pay public debts for the people is to claim the owner cannot be an owner if he agreed to be the accommodating party for a debtor person. If the people are truly the principal, then know how to handle their financial and political affairs unless they have never been taught. If the owner admits by his action of ignorance that he is an accommodating party, he has taken on the debtor's liability without getting consideration in exchange. Here lies the fiction again. The owner of the thing does not have to knowingly agree to be the accommodating party for the debtor person. He just has to act like he agreed. That is easy if he has a choice of going to jail or signing for the debtor person. The presumption that he is the accommodating party is strong enough for the courts to hold the owner of the thing liable for the tax on the thing that he actually owns or owes. Debtors may have the use of certain things, but the things belong to the creditors. The creditor is the master. The debtor is the servant. The Uniform Commercial Code is very specific about the duties and responsibilities a debtor has. If the owner of the thing is presumed to be a debtor because of the previous admissions or adhesion contracts, he is going to have a difficult time convincing the United States that it has a duty to discharge public debts for him. In addition, the court is staffed with loyal judges who will look for every mistake that people make when trying to use their remedy. Now, the quasi-owner, user of the property thing after learning the law and discovering who he is in relation to the United States corporation, can file a UCC financing statement based upon the security agreement, registering his security interest with the artificial entity, debtor person, being the ens legis, which the United States created for you after mom signed the root of title, newborn identification, and was compelled to apply for a birth certificate. That was the act of registering her biological property, her baby, her substance, with the state of XYZ. The United States holds the paper title, the form, not the substance or the body. And so you got to know too that the paperwork only makes reference to the baby. It is not the baby. They only have jurisdiction over the paper, not your fucking children. Okay. Until your financing statement is filed, the United States is the holder of the title to the artificial entity. Its name is spelled in all capital letters, John Henry Doe. When John Henry Doe files the financing statement supported by a security agreement signed by the artificial entity, all caps John, and the owner, upper lowercase John, he becomes the holder in due course of the title to John. The UCC and the state commercial law are very specific about the effect of registered security interest. It has a priority over over other interests only claimed in the same thing. The evidence that is missing in the court is the registered claim over the person's John. And so that's why when you have your proof that you filed your UCC and that you have superior claim over the all caps, they are no longer allowed to move forward without literally fucking willingly committing a criminal act. Okay, so the owner must also notify the Secretary of the Treasury that he is going to handle his own affairs in the future. That is done when you do the chargeback process, which also includes private registered bond for investment filed with the Secretary of the Treasury in Puerto Rico in respect to the value extended thereto per the directives of the Order for Deposit Management and Investment. The directive cover letter, a copy of which is provided to the U.S. Secretary of Treasury as courtesy and notification. Think of this whole transaction in relation to a dead battery. The battery represents your public person, John, which is a dead entity that can function within the public maze of fiction, transmitting benefits from the public to the designated beneficiaries. If it is managed properly and charged up, you cannot go into the public because you are not a fiction. John has no power until it is charged with some energy. So when you, as the owner of a thing, registered it with the United States or one of its subdivisions, you let the United States hold the legal title to your thing based on misrepresentation and failure to disclose material facts to you at the time of registration. You probably retain possession of the thing because the United States invested the title and made a profit. If you did not specifically authorize the United States and its agents to invest the legal title, the profits made from the title belong to you. Because of the owner, you remain the equitable title holder. Legally, all profits from the investment of the titles to all your registered things must go into a fund for your benefit. If they did not put the profits into a trust fund of some sort, it would be fraud. Just acquiring the titles through what is promoted as mandatory registration is fraud. It is the scenario attributed to the Mandel House is now full application to the United States, which it is the officers of the United States that could be charged and convicted with treason if they had not provided a remedy, which they did. This is the insurance policy to assure that they are not convicted for treason. That does not mean that they cannot be charged with treason, but the courts will dismiss based on failure to state a claim upon which relief can be granted. Right? So he who brings the charge must bring the remedy as well. And these motherfuckers always act like you just have to deal with their bullshit. Like, no, the fuck I don't. Okay? Because you have a remedy outside the court, you cannot sustain a charge of treason. But tort, now that's another matter. Now look at that. Now you have breach of trust, tort, and all that shit as claims as well to bring against these clowns. So look, it is a game of chess. Stop playing checkers with these assholes. UCC is a real thing. Promissory notes are a real thing. Bonds are a real thing. Okay? And you can do it all. That's private banking. So that's what I got for you for now. Until we meet again.